हाँ, एक मिनट, एक मिनट, एक मिनट। हाँ। આપને બેઠા બેઠા આરામથી સબમિશન ના કરો. ના પણ એને પણ ન કહેવાય આવી રીતે. ધીસ ઇઝ નોટ ડિસિપ્લિન. આપણી અહીંયા I think by this much year of practice, you should be aware what is the court discipline. And I am totally against this. Don't do this. Please don't do this. કોણ આવશે? શું કામ લઈ આવે? તમને નોટિસ આપણે આપીએ હાથમાં બજાવવા માટે, ત્યાં તમે આપજો એટલે ઓટોમેટિક ખ્યાલ આવશે કે ત્યાં છે કે નથી. નહીં હોય તો એ લખશે કે ભાઈ અહીંયા નથી આ જેલમાં. અહીંયા ટ્રાયલમાં નથી હાજર રહેતા. વીસી થી ચાલ લાવતો યાર. So you want transfer of the case on the basis that co-accused has been granted bail. Exactly. Yes. Or two of you. The one has been dismissed by the Supreme Court. Both the accused role is same. They are on the same. When was that order passed? When was that order granting bail was passed? Whether that order is challenged? Like
Yes, from my side, I agree, sir.
you have challenged. You have filed your opinion to challenge that order. And what has happened about your matter?
What is the issue?
Notice
Not
this.
yet.
And when it is kept,
I will contact the, say that.
you take the direct service and solve that accused. And who is that accused? Who is granted?
Say that,
Who is granted the
say that. Case number 3. Legal offer number 4.
opener number 2 is solved?
Yes.
Opener,
No, offer number 2 is not missed.
okay, he is absconding.
That's one.
Opener number 3,
Offer number 3 has been delivered.
opener
4
number
has been delivered. With the has been delivered.
આ લોકો પોકાર કરામ 3 4 5 અરે 4 5 4 અને 5 you also can inquire what has happened to your opinion in legal department, whether any certainly it goes without saying. તો પોકાર કરો.
વિશ્વ જિગ્નેશભાઈ રામી જયરાજ દેસાઈ જયરાજ દેસાઈ સુનિલ ગજાણિયા સુનિલ ગજાણિયા
અને ટ્રાયલ કોર્ટમાં હાજર રહે છે આ લોકો 4 ને 5 હાજર રહેતા હતા. હવે કઈ તારીખ છે? ના કોર્ટ રજા ઉપર 4 ની કોર્ટ તો હશે ને? 30 8 આરોપીઓ તો હાજર રહેતા હશે એ હજી કોઈ મહેન્દ્ર ઉર્ફે નામદાર નામદાર જ છે. અમને નામદાર કેતા નહીં તો પછી હા એ આપી પણ નામદાર તો બરાબર નામ છે ને મોન્ટુ ઉર્ફે નામદાર એમને પેલા માટે હાથોહાથ આપી દો. અને ક્યારે રાખવી છે? ત્યાં 30 તારીખ છે આમાં 30 રાખીએ કે એની પહેલા રાખવી છે? તમારે કેટલા દિવસ નડિયાદ જેલમાં આપવાનું છે? 28 ફાઇલ. યસ
JM Talota. Okay, JM Talota.
Okay.
लेकिन इसलिए जीएस पटेल एक मिनट जीएस पटेल कभी से एमएम से ओके एमएम से कभी से एचएम प्रजापति ओके एचएम प्रजापति
સાક્ષી માં છે વેક્સિન બોલે લો યસ
I am the owner and entity of a hospital called specialty hospital. Relating to the affairs of this hospital. Richard is the wife of the appellant. The operation was conducted by a certified practitioner who is already registered with the health department and the hospital to which the visiting faculty has appointed. Is the visiting faculty. They conducted the surgery. After conducting the premature delivery, the wife of the appellant and the child both are safe because there were ample amount of complications. So the first submission is this way, that I am being an owner, there is no bar that I cannot own the hospital, being at PROCEEDINGS hospital. But the surgery was conducted by a gynecologist surgeon. And the papers which have been produced by that. Second submission is the entire incident did all the against that the payment of 50,000 was told to them for a cesarean section. I have cleared on record the dispute with my reply. There were two surgeries which have been conducted, one was of section and another was of interest one because there were huge amount of complications. The wife of the appellant was 4 times pregnant and that's why the womb was not advised. They do not wanted to pay 1,85,000 because the actual bill amount of so and so, and that's why this entire proceeding has been started. So they went to the police officers, they filed a complaint, the complaint was not registered after the preliminary inquiry was served. They went to the High Court to get a order for registration of FIR, where the court has observed that if the case is made up, then you may register. Police initiated another inquiry, called everyone on record, take evidences and everything, and the case was not complied with, so it was not registered. Pursuant to which non-registration of FIR, he has filed this application under 200, which is also rejected by the court below. But there is one observation which was kept open, which my lord pointed out on the last occasion. Okay, there is an observation that the medical officer, the Dakshin Zone medical has been initiated. In pursuant to that, the municipal department initiated an inquiry. We tendered our reply, and till date they have not issued any notice, and the matter is put to file. That is what my submission is. Same way they have approached to the another department where also it has been put to file. Another of homeopathy, medical council of homeopathy department, they have filed an application for that also. So it has also been put to file. The only submission is that they do not wanted to pay this 1,85,000, which is a legit bill of a hospital. The entire incident has taken place. And therefore, considering my written arguments and everything, this application is required to be rejected.
Still, my only submission is that first operation was conducted by Dr. Nayak, opposite party number 2. Initially, when the applicant's wife contacted the doctor, 50,000 was agreed towards the cesarean surgery. She did the operation and the applicant's wife gave a birth to a child. And thereafter the complication arose and she did not stop the bleeding. And subsequently she called Dr. Chetan Madhukar, a specialist gynec. Then after he did the second operation and all the things were kept better. એટલે my submission is that initial operation the operation to Dr. Nayak એ કરવામાં આવ્યું, which she is not supposed to do. Being a homeopathy doctor, she is not having a degree of MS. I am not on the point of negligence. I am on the point of conduct of the doctor. So what she is not supposed to do, she did. And complications arise, and she put the endangerment of the life of the patient. બીજું એ છે કે subsequently 1,87,000 રૂપિયા લાગ્યું plus 50,000 bill was given towards the medicine charges. The applicant paid 50,000 as agreed. એને હિસાબે સર high volume cough organized.
Difficult to correct, not a single amount has been paid.
Okay.
Counter blast પર સાહેબ એમને પછી
Counter blast ને blast આપણે જોઈએ. First, both of you make clear. At the first instant, you both of you said that we have given our written arguments. We do not want to argue. Now you want arguing. So better make your stand clear whether you want to argue or not. If you want to argue, please start.
I also relied on my reserve. I just wanted.
No, I am not telling you no, don't argue. I am just asking you whether if you want to argue, make your case out.
I just want to recollect it.
Yes,
I have
yes,
already
yes.
submitted it.
Because I have not heard you, therefore there is no question of recollecting. So far as I am concerned, that is, you have submitted your written argument, which I have not gone yet. So today, you may argue if you want.
If you want your lordship, you will go through it. If there is any query, we are ready to solve the query subsequent stage.
I don't have any query right now, nor I would adopt that practice.
Against his argument, I just only want to know, the application was given to the health department AMC.
So what was your complaint before the magistrate?
Magistrate complained in the 17th second to lodge the FIR against the Dr. Nayak. He was the homeopathy doctor and she did the operation, application, applicant's wife. So the, at page number 2 of my written argument, I have already submitted the facts for my application. So that may be considered. I don't want to repeat it again. The only thing that what we told,
So you wanted to get your FIR registered for the
Yes.
IPC offences as well as medical negligence. Now, what is the order of the magistrate court?
the state court has not taken the cognizance and that report was given by the police, negative report was given by the police. My submission is the no CCTV footage to take around. So that it may come out with whether the doctor has gone for the first operation or not. The health department, the corporation will indicate the hospital. And hospital must be found Dr. Sippa Nayak is the PHM doctor. And they took photograph. They said the RTI is murder with the document presentation. And is that they subsequently they gave the verification from the Chetan Madhukar, who was subsequently called as the visiting doctor, gynec visiting doctor. If the patient was having a sort of complications and we did the operation. My submission is that first operation was conducted by Sippa Nayak, which she is not supposed to do. That is my only submission. Question of negligence comes subsequently, but I am on the conduct. He's refused to pay the FIR. He gave an application before, private complaint before the court, court number 4, like metropolitan ministry. He said, other things here. I read the order. यदि आमिर अपोकन प्रकरण खानगी फरियाद फरियाद कथन करता दस्तावेजी पुरावा ध्यान देता आरोपीए फरियादी સાથે કોઈ છેતરપિંડી કરી હોય તેમજ કોઈ મેડિકલ બેદરકારી આરોપીને દાખલ હોય તે સંબંધે કોઈ તત્વો જણાય આવતા ન હોય ફરિયાદ યુનિયન કોન્સ્ટેબલ પર 203 અન્વયે કાઢી નાખવાનો હુકમ કરવામાં આવે છે એવું સ્પષ્ટ કરવામાં આવે છે કે હેલ્થ ઓફિસર દક્ષિણ અમદાવાદ મ્યુનિસિપલ કોર્પોરેશન વાળાએ ફરિયાદમાં જણાવ સામેવાળા પબ્લિક આરોપી ડોક્ટર શિલ્પા નાયર પાસે માત્ર PHMS ये डिग्री होવાનું તેમજ એલોપેથી પ્રેક્ટિસ કરતા હોવાનું પ્રથમ દ્રષ્ટિએ આરોપી દ્વારા લોકોના આરોગ્ય સાથે ગંભીર છેડછાડ કરતા આવતા હોવાનું જણાવ્યું હોવાનું તારીખ 2020 ના પત્ર લખેલ છે તે સંબંધે આરોપી શાળાવાળા સામે સરકારી કચેરી શ્રી સરકાર તેમજ ઉચ્ચ અધિકારીઓ સમક્ષ આ હુકમ કરી અને ચર્ચાને આધીન ફરિયાદ
તમારી સામે પણ ગુનો નોંધાયો છે તમારી સામે શેનો ગુનો નોંધાયો છે
તો 506 છે 114 છે हाँ 294 B 5062 and 124 of 95 and against the said FIR, special criminal application 17-86 of 20 was filed before the ICC.
again this FIR you file special criminal yes. For what
Precaution.
for caution what happened in that complaint
Even the current order करवा लेकिन not to arrest the person. It is pending for filing.
you had paid rupees 50,000 to Dr. Shilpa Nair
Yeah, that they agreed. As agreed amount.
as agreed you paid rupees 50,000
That is what instruction given by the.
thereafter you went to Dr. Vaibhav Patel
No, she referred.
referred therefore you all
The
went
child specialist. And he gave a bill of 1,75,000 for the child.
that was paid by you that bill was paid by
That
you
is, no, it is pending.
it is pending
paid.
so that is the dispute
That is that.
yes
May just correct.
Because of complications in operation,
yes
the child also suffered and subsequently he was shifted to Dr.
So I just correct the.
Synergy Hospital.
I just correct the submission. His allegation was that the amount of 50,000 was towards the cesarean section. But there was a two operations which were conducted, one of a uterus and all the operations have been conducted. So I differ with my learned friend that the Shilpa Naik has conducted in operation. Both the operation was conducted by a certified gynecologist, Mr. Chetan Madhukar. The child was premature. He was born in the 8th month. The mother and child both were in a very severe to death condition, basically. The child was born prematurely, so it was important to send him to NICU. So Dr. Shilpa, the hospital of Dr. Shilpa referred the patient to Vaibhav Patel.
Synergy Hospital.
See, the another hospital
synergy
Synergy Hospital.
to keep this child under NICU, that is an incubator, my lords, to save his life because he was premature. It was compulsory to put him under the incubator. So where the invoices was of 1,75,000 and this hospital invoice was of 1,85,000, where I have put the invoice also on record, my lords, along with my reply, where a cesarean charges. Operation of a cesarean charges was imposed as 50,000 only. The rest is room charges and all the bifurcation is given. Page number 37 with my reply. So consulting charges was, there was room charges, doctor visit charges, nursing charges, anesthesia charges, surgeon charges, operation theater charges, cesarean charges, AH operation charges, and other charges of blood. This is blood charges. And total 1,85,000 નું invoice આપેલું. Just to clarify this. And just because he didn't wanted to pay this amount at all, he has initiated this entire proceedings.
Initially 50,000 were agreed towards the cesarean as a package. It includes all charges. That is what decided between the parties, doctor and patient.
આજે સર સબસિક્વન્ટલી જે બધા ચાર્જીસ લગાવવામાં આવ્યા છે કોમ્પ્લિકેશન એરાઇઝ bleeding could not stop અને જે સબસિક્વન્ટલી ડોક્ટર મધુકર was cooled and he did the second operation એટલે એ બધા જે કોમ્પ્લિકેશન્સ થયા છે તો મારું સબમિશન એટલું જ છે કે the first doctor did the operation and because of such operation the complication arise. That was the correct fact which was given by the patient. My learned friend said that the AMC Health Department and Medical Council has recorded the application, but the only reason for recording is that matter is subjudized before the court. They did not take any action.
My lords, my reply is given and then after they have not initiated anything. So it is from last 3 years, it could have been put to file. Because I have tendered my reply in return with along with all the papers which are submitted before this court.
One period she has not handed over the original medical file. The same has been detailed by Dr. Nayak.
My lord, he has not approached from 21/8/2020 till December, March of this.
First fact is pertinent to note that she did not refer the birth of child to the health department AMC.
She has done already and handed over
That was- that was-
to the
That
birth
was done
certificate to them.
That was done subsequently after issuing the notice.
But he has not come before the hospital since the day he has taken discharge. He has never come to the hospital to ask for birth certificate. And on request of my learned friend, on last to last occasion when it was handed over, it was told that tell him to come and pick the birth certificate of a child because it was already registered.
Yes, sir, જે કંઈ કર્યું છે હવે એક દોઢ વર્ષ પછી કર્યું છે. Even
But સાહેબ, એ
after
આવ્યો જ
issuing the notice, yes, sir, written notice આપી હતી ડોક્ટરને and subsequently she called me. અને એ યાદી
સાહેબ એનો રિપ્લાય પણ આપેલો છે.
યાદી સુધી કોર્પોરેશનમાં મોકલી નથી and corporation demanded the affidavit from my client. કે તમે affidavit ફાઇલ કરો હજી સુધી યાદી હોસ્પિટલમાંથી આવી નથી. એટલે she intentionally did not send the
સાહેબ, એમાં
birth
it
યાદી
is
to
the
the
patient's and parents' responsibility to approach to the
she has
hospital
not
and
sent even
પછી
the
અમને
original medical file. એમને જે કન્સલ્ટ કર્યું છે એના આજે બધા ઓપરેશનના નોટિસ ને બધા રાખ્યા છે ઓરિજિનલ ફાઇલ હજી ચેન્જ કરી છે. It is not given to the patient.
because the amount is not being paid.
Copy of notice which was subsequently issued to Dr. Nayak for not giving the detailed information to health department regarding the birth of child. It is not on the present record, sir.
સિઝેરિયન કોણે કર્યું છે?
ચેતન એસ મધુકર.
For my submission, initially first cesarean was done by the Dr. Nayak.
Both the
Subsequently,
certificate.
after realizing complications, he called the receiving doctor.
ડોક્ટર ચેતન
ચેતન મધુકર MANDHUKAR.
અને બીજું ઓપરેશન કર્યું એ
બંને ઓપરેશન અમને કર્યા સર.
અને
કારણ કે
આ
એક જ દિવસમાં ઓપરેશન થયું હતું. સિઝેરિયન થાય
બંને ઓપરેશન પેલી મણિનગરની હોસ્પિટલ
એ જ હોસ્પિટલમાં ઇન્દિરા હું એ હોસ્પિટલની ઓનર છું. મારી હોસ્પિટલમાં ચેતનભાઈ એક વિઝિટિંગ ફેકલ્ટી છે અને એમનો ઓલરેડી એમનું નામ મ્યુનિસિપાલિટી હેલ્થ ડિપાર્ટમેન્ટમાં રજિસ્ટર્ડ છે અને મારા ત્યાં સાહેબ મલ્ટિપલ અલગ અલગ ઇટ્સ અ મલ્ટી સ્પેશિયાલિટી હોસ્પિટલ. આઈ એમ ધ ઓનર ઓફ ધીસ હોસ્પિટલ. બંને સર્જરી ચેતનભાઈ અને એમની ટીમે જ કરી છે.
Where could have been not the thorough investigation could have been done. The initial stage of process data treatment like negative report application.
Why 406, 409, 420, 467, 468? You want that FIR should be registered for these IPC offences. You have made a prayer that offense under section 406 and so sections should be registered. Now why 406, 420, 409?
It was the fraud done by me. Initially, for the amount was agreed and subsequently she asked for the higher amount.
But that you have not paid that amount. Did this hospital call you to go for delivery or cesarean operation? Whether there was any offer to you? No. You went in an emergency situation.
No, she was going regularly.
She was going regularly, but whether they called, there is no, your FIR do not say that they had offered you something and you accepted there.
It was orally,
Orally.
during consultation.
Your FIR says that in an emergency situation, you went to the hospital.
She was going regularly.
She was
Follow.
going regularly, but due to abdominal pain, she went.
She was having a heavy pain and she.
Heavy pain, she went.
She absolutely contacted the doctor. She told me it is required to do
Do the operation. Yes.
Those
How,
people-
how
those
offense
people
of,
under the age.
how offense of criminal breach of trust and offense of cheating would be attractive?
Cheating in the sense that she demanded the higher amount against the what is agreed between the parties.
There was no agreement. It was a fee, the normal between a doctor and
Even
patient.
after operation, she insisted to the child to Synergy Hospital. I know Vaibhav Hotel.
That is, see, that is a
nearest
normal,
person.
in an emergency situation, the doctor refers someone to some other hospital for better treatment, for better. Now it is your choice whether you should go or you should not go.
Complications to the patient and complications to the child arise due to the operation done by the simple. That is
You are
my-
right, but now you are contending that I am not on medical negligence.
Yes, correct. That is required to be proved through medical expert.
Medical
I
negligence.
am on the point of contact.
So
Just he
therefore,
conducted the operation, what she is not supposed to do, CT.
see, medical
Having a
negligence,
homeopathic degree.
but the operation or whatever treatment was given, it was by doctor.
It was given by Dr. Chetan
Chetan
subsequently. After arising complications, that is my case. Initially, she did the operation, and after having a heavy bleeding, she could not stop the bleeding, she called the gynec specialist.
What is there to believe your say that the cesarean was done by Dr. Silpa Nair,
Yes.
who is a homeopathy doctor, except your say. Do you have anything? No. Unless you point out how the court would believe.
All the original papers, all the medical files related to the consulting are detained by the Simpana. She has not given the original.
That was after.
Initially, when the patient consulted her during the follow-up also and during the emergency, whatever notice she has done in the file, she has detained the file, she has not given the. Till date, she has not given the.
There
And
say,
as a corporation is on the Khulasa Abhiya se Chetan Madhu kare. That was all given subsequently. As per the patient who knows the correct fact, and she knows that Dr. Silpa Nair has undergone the operation cesarean, first cesarean.
so she has
And
not
after having a complication, she could not stop the bleeding. He subsequently called the visiting specialist gynae, Dr. Chetan Madhu. And related to all these documentary proofs, she has detailed. She has not given the file.
એક 75 છે તમારી હોસ્પિટલના જ છે.
ના મારા એક 185 છે એક 75 જે છે એ NICU જે વૈભવભાઈના ત્યાં એમના છોકરાને મૂક્યો એના હતા. My case is only of 185. I'll just point out one, I can show one document which will clear the query. On six,
Now,
8, 20.
why 185 for cesarean?
So there were two op surgeries and they were on the back to back. On 17th, when the patient was admitted, I'll just show from the reports, my lords. With my lords, with my reply, I have filed a document at page number 1. From
Even she told the present applicant to arrange for the blood. When he went to arrange for the blood and medicine, he took out the uterus without any permission.
no, I have taken સાહેબ સમજૂતી વગર તો કશું થયું નહીં. સમજૂતી એમના પોતાની signature છે.
That consent is before the operation.
હા
Before
તો
the cesarean
એ
operation.
છે સાહેબ, એમને કન્સેન્ટ આવ્યા પછી જ કોઈ પણ ના થવા દઉં સાહેબ. એ 6/8/2020 they came in rushing.
Instead of replying to his query,
હા,
you just reply to the court's
he was interrupting, that's why I'm extremely sorry. On 6/8/2020,
Why 185?
there is a bifurcation given at the page 37. My lords may see the entire bifurcation is there. There are the hospital charges are divided into multiple charges. The room charges, ICU charges, anesthesia charges, cesarean charges, operation theater charges. So the total plus medical expenses comes up to 185. The blood charges was of 1500. 5 bottles of blood were imposed were put on her. Right, the AH operation charges was 70,000. The cesarean charges were of 50,000 because there were two surgeries, one of cesarean, the another was of this uterus removal. The operation theater charges is also there, and this is the period of a COVID-19, my lord, where at that time it was very hard for any hospitals to look at it. So that this is the basic charges. It is on a, I will just put this way, this is on a lower side. What right now the hospital charge, it is actually on a lower side.
At the
It
time of
will be
agreement,
lower for you.
Definitely I understand, but right,
You are running a multi-specialty
Hospital, yes.
therefore you would be, you won't, I don't know.
I will not be able to sell what other
at the time of deciding the
Please,
package, no clarification.
please,
I'm
either you both keep on arguing between inters, I will take another case. See, your bill do not suggest that you had done some concession to this patient.
that is not done.
So there-
It was in a
so-
sort of emergency.
That should not be your argument. Okay, as per my submission, it is on lower side.
I agree, I take that back.
You have not given any concession,
concession,
nothing reveals from the case
Yes.
paper. So that your argument is merely in air.
I'll take that.
And being a doctor, if you, even if you give a concession, that should not be an obligation to anyone.
I totally agree. I follow
Because it
that
is
one.
your duty to treat the patient who comes, whether it
Grateful.
is in COVID time or whether it is
Yeah,
another.
it-
And we have seen both the phases of medical profession in COVID time. We
Yes.
all have seen.
Yes. Yes.
Maybe many of have experience also. One was of service phase, another was of professional phase.
Very
That everyone is aware. So
Very-
please
very
don't make
good.
such type of,
I'll take that back. I'll take that back. I'll take it deeply obliged.
don't deeply oblige, feel sorry about making this submission.
I've-
People have paid 20 lakh, 30 lakhs for during COVID times. For
I
fever and,
understand. We have seen that case. Very good.
we have seen such type of cases. And we
Cases,
have also seen that in civil hospital, the patient were treated by the doctor and paramedical staff more better than
And
their
the
relatives.
actual of that.
So this is one good phases and one another is. And I don't know whether your hospital was working in during COVID time.
COVID, yes. it
Then
was.
just show me how much concession your hospital has given.
I would not be able to produce it.
So before making submission. as
I'll
advocates
take that
before
back.
the
I'm
court,
extremely sorry, my lord, because it was a period of COVID, so that is just my submission, that it was. a
COVID
period of-
was to serve the society.
Yeah.
That
I
lesson should
totally
be
agree.
learned by everyone.
I'll take back my submission on that part.
Now it can be taken. Yes,
So I was just pointing out that.
so you have a charge 185 for your,
both
your
both
hospital.
both the surgeries.
for 2 surgeries which you had performed. And 175 is of the doctor.
Doctor, another doctor,
Another
another hospital, another treatment of the child. Because he was
એ બિલ ભરી દીધું તમે? એ નથી ભર્યું.
Not a single penny is paid.
And after paying 50,000, she gave the district.
No. My instruction is that even he has not paid 50,000.
From my client.
He has not even paid 50,000. Even he has taken a discharge against medical advice. And that is produced with my documents on record. Though the emergency and the condition of the wife was explained to him, he has forcefully taken his wife and went away on 20 August 2020.
અત્યારે બંને
No, both of them. Friday, mother, both are.
Both are right.
so why can't both of you sit together
We have tried. We have
instead of quarreling?
There was a proposal from their side, that you withdraw your matter and we will withdraw once the high pass.
So why are you waiting for it?
The amount pending,
You have to pay some amount. How can you say no?
but they can say some amount reasonable.
Reasonable amount, they will say, but
185 and 175.
175 is not my concern.
see, we are not on marriage. When a patient goes to a hospital, he is to be treated by the doctor. At the same time, the situation are such that you will have to give your consent. Okay,
Correct, but it seems that she has
But-
taken an undue advantage of the situation.
that we are coming next. Undue advantage of, you were taking treatment at that hospital.
That's why we
First, you were taking treatment. You were happy with the treatment till that bill amount dispute arose between you. That on emergency situation, you went to that hospital because you were taking treatment there prior to your admission in that hospital. So till that you did not have any objection whether he is homeopathy or Ayurvedic, whatever. As per their say, Dr. Chetan has treated them, who is the MD gynecologist.
It is not my case. My case is that.
Your case is not, it is his case.
Okay.
Now that has been inquired by the police also on pursuant to your complaint. And it is found that you did not wanted to pay the money and therefore you have arose this dispute. And one FIR is also filed against you for creating a chaos in the hospital. Now both the child and mother are happy, they are healthy, except the money dispute. That has become unhealthy between the doctor and patient relationship. Pay some amount and settle this dispute. Why you want?
I have told my learned friend to, that we are ready to settle.
You have given the proposal.
I have given
The
the
proposal is that you withdraw your application before the.
Yes,
Yes, sir, certainly.
But why you want to now? What is born? Baby or boy or girl?
Boy,
Boy.
Boy, very good.
So how many children do you have?
this is the fourth one.
Fourth one. How many girl and boy? Where were they born? In this hospital?
No.
Other,
Others.
all are cesarean. Yes, do you want anything? I have heard both of you.
Right, great.
If you want to try, ask both of your client to remain present before the court. I mean, you can't see, you have whole dispute arose when bill was given you.
The main dispute arose that she took out the uterus without the permission.
That was an
And because
emergency
of that, the
situation.
complication was
There
arised.
is your consent form. I have also seen the consent form. That consent form you have given in any case of emergency situation, they would be at liberty to do, give best treatment and take best decision. And fortunately, both of them are alive and they are healthy now. So that is one inference can certainly be drawn that they took the decision and they are survived. Respect goes in their favor. Call your client. He can't create a havoc in the hospital. He might have dispute. We don't know whether it's genuine right or wrong dispute. He might be having dispute, but he can't take anything. You also withdraw your complaint.
We are ready. We have given them a proposal, but we have been harassed by.
Okay,
This is all department.
I have heard you. I have given enough time to both of you.
Grateful.
Both of you go out of the court, talk to your clients and reply right now only.
For
Whether you are willing
on the part of settlement.
on the part of settlement.
Right.
You leave some your amount of
Yeah,
your
yes, sir.
charges.
I'll just have a word.
And you pay some amount. Otherwise,
Grateful, lordships.
otherwise doctor would not admit. See, there would be a situation if we keep on fighting like this. Doctor would not admit the patient without money. First, you take away that patient. And secondly, if there is fault on the part of doctors, then they would lose trust in doctors also.
At the time of agreeing the package of 50,000, no clarification was done that in case of
50,
complications further amount.
Everyone knows. If it was for cesarean, it was 50,000 as per your say. Now some complication arise. For that complication, we can't say, okay, no, it was 50,000 only. You might require other expenses also. People generally have that belief. You wanted a better hospital. Otherwise, there are other.
The honorable court is that it may be if possible kept at the next week, so I.
No next week.
Even he can call the client and I
next
will
week.
call the
No,
client.
no, no next week. Take telephonic instruction from both of your client, whether they are agreeable to or not. How they are agreeable, that we will decide later on. But first get this clarity. And advise your clients. You also.
Yes.
They are doctors, they have to do some charity also.
Yeah.
So do some charity. I'm not telling to,
Definitely, I take the sense of my client.
and you also,
Grateful, lord.
and he can't get everything free, huh? Keep this in mind. And one thing also, you also keep in your mind that your FIR is not registered by the police, knowing that no offense is made out. Before the magistrate court, the court has dismissed your complaint. With this fact, keeping in your mind, advise your client also. And you also advise that revision can be allowed. બેન શાંતિ તો લેવા જો એક કેસમાંથી બીજા કેસમાં આવવા માટે બેસો શાંતિથી રાખો થોડું.
One 98, 406, 323, 504, 506, and 34. The durations of this, I mean, the crime which had been shown in the fire itself is right from 14th March 2012 to 2nd of March 14. This appears to have been given deliberately
Your
by the
application was for discharge.
My application is for discharge. So far, this complaint had been lodged against the husband, father-in-law, sister-in-law, and sister-in-law. I'm not for the. I'm not the father and the husband is not the my loss. Only the father-in-law and the sister-in-law is the party for caution.
Father-in-law, mother-in-law, and sister-in-law.
No, mother-in-law is not joint.
Yes. He is released.
I'm sorry. I'm sorry. No, 3 are joints only. Yeah, your mother is also Tejas and all 3. The mother-in-law, father-in-law, and the sister-in-law. The allegations which had been leveled. Before I'm dealing with the allegations, yeah, honorably see that the marriage had been taken place on 26th of April 2012. At Ahmedabad. It was Malos, she was serving somewhere at Delhi, and the boy was at Canada, and therefore something had been arranged But this is an arranged marriage, not the, I mean, the love. affairs. And the allegations are leveled that some facts regarding the marriage had been concealed by the husband. But since there is no charge under section 42402, that absolutely remain, I mean, having no value in it, because they're the only cruelty 406, 423 and 4. So I will be dealing, my lord, this perspective to the section which have been applied only. Now, in this complaint, if your honor maybe find that she has left the house with the consent of the in-laws. I may become that, see, according to Shu, that there was a cruelty in the part of the in-laws, and therefore the father had been called. Father had come from the Pune, they have sitting. That we'll find on the page 6, my lord, of a complaint, internal page number 6. And before 8/9/2012, he has left the house of the husband. Thereafter, she has never come to. But this in complaint, my lord, the FIR, they have extended the time of 2nd of March 2014 with the ulterior motive, I think. So this complaint is in fact, my lords, led by 2 years. Apparently by 2 years. Because after 8/9/12, she has never turned up to the matrimonial home. Now, allegation which had been leveled against all this, I mean, the in-laws are, I'm not for the husband, and therefore I will be skip those allegations which had been made against the husband. And I will be deal only with the allegation which had been leveled against the father-in-law, mother-in-law, and the sister-in-law only. It start, my lord, the allegations start from page 4. The first part is the strike of the non-giving information regarding the,
Okay, since you are on discharge,
yeah.
note under 482. I would request
No, no, the
grounds-
basically,
the grounds for pausing
and
FIR after 2 years, and we are concerned with whether there is sufficient material
no, I'm coming. I'm coming.
for which you should be put
I-
for
I'm-
trial or
I'm
not.
coming to it.
Yes.
I understand that the caution is power with the Honorable High Court, and this is a discharge application.
Since
But
now,
since the,
now charge sheet has been filed and you are for discharge, your discharge application has been rejected by the trial court.
yeah,
So your contention would be confined to the extent that whether the evidence as in the charge sheet is sufficient to frame charge or not.
I was expecting this thing only. I was just expecting my big man.
Because I would not be accepting your argument now, nor I can go
And the 4G.
under 482.
No,
So that argument, even if you raise, an
I'm
appeal, even if you raise and even if it appeals to me, I won't be able to go or give any decision on that point. I have to confine myself only on the evidence which is collected by the IO and whether it is prima facie sufficient to put you on trial or not. I can go even in your defense also at this stage.
You cannot go in defense also, I understand. Then what happened is that whatever is stated in the complaint itself has to be having a prima facie value.
Prima facie value, whether it is sufficient to put you trial for offense under section 498A, 406, 420 or not.
Now, I'm with the judgment of 482 only. I'm equipped with this 482 judgment by the Honorable High Court. What I want to submit it, that of course those powers are different. But the basic thing is that whether it constitutes the offense or not.
Yes, that
There also they have they decided if the allegations labeled against the complaint, the accused are not, constituting any sort of offense, then
No, before
I'm
there,
I'm conscious of powers.
you would be having some room to put your defense. And court has inherent power.
That will be matter of a trial.
No.
So in a vexatious
Even
case,
see, even if
but
there the court can at least prima facie look into your defense also, whether it is right, wrong, whether the complainant say is wrong or right. Here the court will have to confine itself on the basis of charge sheet papers only.
then my lord, the admitted thing is because a very wisely drafted complaints, putting an allegations on somebody against somebody. If accepted as a prima facie, though it is vexatious, one has to face the trial for the life.
Yes, I understand.
But I just want to,
That is reply to your contention is that there is a provision of discharge. And there are instances of discharge also.
Yeah.
Subject to, it falls within the limitation of discharge.
I just want to submit that this appears to be allegation, there are allegations, but appears to be an vexatious one thing. Second thing is that whether it constitutes the cruelty is defined in section 498A or not.
Yes.
I will be posed to that extent. Because nowadays what happened, in numbers of the judgment, the Honorable Supreme Court as well, the High Court is also. So wherever any law had been enacted by the parliaments, in favor of a class of people, they have certainly taken the disadvantage of that laws.
Every law.
Everyone. So here they were trying to rob the entire family for making a vexatious allegation, trying to rob the entire family. That is the difficulty.
That is the difficulty, that we have elected such people who make such kind of law.
One must be very cautious before getting married.
Even if you do not get married, then there are other laws,
Other problems also.
other laws, which can
And understand. But this is my reading, the Rent Control Act, Atrocities Act.
atrocity.
Then this Genders Act, which have been given the protection to the women. The people have taken the disadvantage of it.
Everyone knows this fact.
And that's why we have here one the causing that we should not be, for the long period to attend the court for the purpose of facing the vexatious litigations. That's why I'm putting that.
There was one.
The normal, the behavior we are expecting from the people, if that has been, because it appears from this allegation only that these appears to be vexatious. Now I'm just taking the first allegation which had been leveled, that at the time of a marriage, before marriage, had been demanded 50,000 rupees and 15 tola son. That they have agreed, but that cannot be now issue for making allegations. Now in the second paragraph in page number 4, Milos may say, લગ્ન પછી ઘરે રહેવા ગયા મારા શરીરને મા બાપના લગ્નના 15 તોલા સોના દાગીના સુરક્ષા માટે મારી પાસેથી કઢાવીને મારી નણંદને આપેલા હતા. Generally in our society, if newly married woman is coming to the home and there is an entrustment of even in the ornaments, they will entrust these ornaments to the parents. So apparently this conduct of making an allegation that it had been entrusted to the sister-in-law, apparently against the natural conduct. And therefore I'm saying that it is the vexatious one. Now, Honor, we will find it in page 5th, because there are no other allegations. I'm skipping certain part of it. I'm confined myself to the allegation level. Now on page number 5, Madam, see, Nani on from bottom 6 to 7 line from bottom. નાની નાની બાબતો સાફ સફાઈ જમાના સમયે નીચે બેસવા તું અમારી સાથે જમાને લાયક નથી ફક્ત ઘરમાં જ કામ કર બહાર ક્યાં જવું નહીં. Now who made this I mean who has said this? There is nothing. Silent. પછી તથા મને મારી નણંદ તથા પિતાના પગ દાબા માટે જણાવતા હતા. ત્યારબાદ મને ભૂખ્યા પેટે રાખી ઘરનું કામકાજ કરાવતા હતા. પણ કોણ ખાવાનું ન આપતું એ બી ક્યાંય નહીં. સાયલેન્ટ. એવરીથિંગ ઇઝ સાયલેન્ટ. The important now thing is that whatever allegation which had level, this sort of allegation against, except that there was on page 6 કે ભાઈ વારંવાર મારી પાસેથી છૂટાછેડાની માંગણી કરવા લાગેલા. પણ એ માંગણી બી the husband was making against the allegations. Then regarding the 323 or other allegations are also against the husband. Important thing is that this, because labeling allegation is a different thing in a complaint itself. But now the investigation is completed. Statement of the witnesses have been recorded. Now you will normally find that the statement of two witnesses which I am equipped with, one is the father of the girl and other is the Jaishri Ben, probably the mother-in-law. A બેના સાહેબ સ્ટેટમેન્ટ આપણે વાંચી તો before I may take your loss to this statement, one allegation which had been leveled, I will just see that how they can be witnessed or not for that purpose only. Now page 6, my lord, from bottom 6 to 7 lines, 10 lines. પતિ પત્ની વચ્ચે કોઈ વખત બોલે છે ત્યારબાદ મારા પિતા મારા સસરા તથા પતિ મને થતા ત્રાસ બાબતે પૂછતા મારા સસરાએ જણાવેલ આ સાહેબ 22/8/12 ના રોજ ફોન કરી બોલાવેલા એમના માત પિતા આવેલા છોકરીના અને એમની રૂબરૂમાં જે વાત થઈ છે એના એલિગેશનો છે. ત્યારબાદ મારા પિતાને મારા સસરા પતિ બંને ત્રાસ આપવા બાબતે પૂછતા મારા સસરાએ જણાવેલ કે પતિ પત્ની વચ્ચે કોઈ બાબતે બોલાચાલી થતા મારા દીકરાએ તમારી દીકરીને હાથ ઉપાડ્યો છે તેમ જણાવી. ત્યારબાદ પિતાએ મને કામથી પૂના લઈ જવા બાબતે જણાવતા તેઓ મને જવાની પરવાનગી આપેલી. Now I am pausing for a moment here. This statement of this father and the mother had been recorded.
So where is the husband?
It's a part of investigation, man. It's a part of investigation.
Husband, where is husband?
Her husband is here in India.
In India.
He was serving at Canada, but since he has come after the marriage, has not able to go because of these all complaints and everything. Now, Jaishri Ben માટે સાહેબ આપને વાંચી so everything she has stated that she had been conveyed by the complainant, Poonam.
Yes.
હવે જ્યાં સુધી સાહેબ એમના બંનેની રૂબરૂની વાત છે એનામાં જોઈએ તો જયશ્રી બેનનું સ્ટેટમેન્ટ 14/4/14 નું છે and from bottom 7th line 8th line 20/7 ના રોજ નાસિકથી અમદાવાદ આવેલા અને પૂનમના સાસુ સસરા તથા પતિને મળી વાતચીત કરી ઘર ના તૂટે તે માટે પૂનમને સમજાવેલ. જે એલિગેશન એને કર્યા છે કે ફાધરે એમ કીધું કે પતિ પત્ની વચ્ચેનો ઝઘડો હશે ને મારા છોકરાએ તમાચો મારી દીધો હશે એવી કોઈ હકીકત આમાં સ્ટેટમેન્ટમાં નથી નીકળતી. ઓન ધી કોન્ટ્રી દે સેડ કે પૂનમને સમજાવેલી and the same statement had been reflect from the statement of Father Dhirubai. apparently those allegations, my lord. બીજું તો કોઈ સાહેબ serious allegation भी નથી. There is no other serious allegation against the particularly father-in-law, mother-in-law, and the sister-in-law. None of the statements of the witness give any corroborations to this complaint. They are all hearsay witnesses. And therefore, because my lord, the tendency has nowadays developed to rob the entire family, some statement of cruelty here and there made should not be a cause for facing the trial. And I am not here for the husband. I'm not here for that. So I'm requesting, my lord, because my lord has restrained me from referring 482.
Yes, certainly.
But otherwise, in that cases has been already observed.
Yes, there are number of judgments.
There are number of-
of washing.
I'm
But
conscious.
since the
It is, I mean, complaint itself, prima facie pieces of excess, yes. And at least allegation level required to be corroborated. So far the, I mean, entrustment to the sister-in-law is concerned, the ornament is concerned, for that also there is no corroboration from him. So this appears the tendency in the part of the complainant because he wanted to rob the entire family for no cause. Yes, sir.
PS Patel and Prakash Rao.
Any date for order.
24.
I'm obliged.
Serial number 12 છે.
July. પિંચાસી બાવીસ સમજાવી સેશન્સ કેસ 85-22 જોઈ લો તમે હા
32 છે 32 પંચ છે.
હમ
હવે એ સાહેબ એની તપાસમાં કહે છે કે મને આરોપી બતાવવામાં આવે તો હું ઓળખી શકું નહીં, મને મુદ્દામાલ બતાવવામાં આવે તો હું ઓળખી શકું નહીં.
32 માં
હા.
સાક્ષી એમ બોલે છે મને આરોપી ને મુદ્દામાલ બતાવવામાં આવે તો
ના, એટલે પછી એને ડિસ્કાર્ડ પછી એ તમોદારે ગેરહાજર હતો એ તો પછી એની ફરીવાર એની પોસ્ટમાં જ રાખેલી તપાસ.
એ ડિસ્કાર્ડ છે બાકી કે છે તો
હા.
આવું જ કે
પછી
ઓળખી
એની
શકું.
જે 21/2/2023 ના રોજ એની જુબાની થઈ સાહેબ. 21/2/2023.
કોર્ટે ડિસ્કાર્ડ કરી છે પછી
હા જી. હા, પછી ઉદય રામ જસ યાદવ 25. એને તપાસેલા છે. હવે એ સાહેબ એ હોસ્ટેલ થયેલા છે, એને કઈ બનાવ અંગેની કોઈ જાત માહિતી નથી છે. પછી તપાસ એ છે મોહમ્મદ યાસીન મોહમ્મદ હુસૈન શેખ 29.
ઊંધા કેમ જાવ છો રામ
જી સાહેબ.
રિવર્સ પેલા
ને એટલે મેં ઓલા અલગ અલગ જે નકલો મળી ને એ પ્રમાણે કરું છું
અરે
સાહેબ.
પણ નકલો મળ્યા પછી તો અરજી કરો.
ના, એટલે એમાં શું છે કે અલગ અલગ જે છે ને 1 by 1 લઉં એવું હોય તો પતી ગઈ છે એમાં.
મને જ લ્યો પણ પેલા 45 ગયા પછી 32 ગયા હવે 29 આવ્યા.
હા, હવે આમાં
ચાલો શું કેવું દરેક?
હાજી હાજી. દિલીપભાઈ કુંદાભાઈ રાઠોડ 45.
હમ
એ હેડ કોન્સ્ટેબલ છે. હવે સાહેબ એ ઉલટ તપાસમાં એમ કે છે કે મને મેસેજ મળેલ તે અગાઉ હાલનો બનાવ બની ગયેલ હતો. મેસેજના આધારે પોલીસે મારો જવાબ લીધેલો. જમાલપુર શાક માર્કેટ નો એરિયા ભરચક ટ્રાફિક વાળો એરિયા છે. હું બનાવવાળા સ્થળે અડધો કલાક જેટલો સમય રોકાય. પછી રમેશભાઈ લવજીભાઈ પટેલ 52.
હા એ શું કે છે?
હા, એ
બીજા કોણ છે તમે?
હા, એ આઈઓ છે સાહેબ. અને એ તપાસ કરેલી સાહેબ એમને.
તમને તપાસ કરી પૂરી
હા,
કરી
એ
ચાર્જશીટ કરી.
એ ઉલટ તપાસમાં એમ કહે છે કે એ વાત કરી છે કે મુદ્દામાલ ટામેટાના કેરેટ તપાસ દરમિયાન મળી આવેલ નહીં.
હમ.
જે મુદ્દામાલ જે ગયેલો એની કોઈ રિકવરી થયેલી નથી સાહેબ. એ પછી કહે છે કે એ વાત ખરી છે કે તપાસના કામે મેં કોઈ સીસીટીવી ફૂટેજ મેળવેલે નહીં.
જરૂરી થોડું સીસીટીવી લેવા જ જોઈએ.
ના, એટલે બનાવ કઈ રીતે બન્યો સીસીટીવી ફૂટેજમાં એ પોતે જ કહે છે સાહેબ. અને પછી આગળ કહે છે કે એ વાત ખરી છે કે આરોપી નંબર 2, 3, 4 સ્થળ પરથી મળી આવેલ નહીં. તેમની કોઈ ઓળખ પરેડ થયેલ નથી. એક્ઝિક્યુટિવ મેજિસ્ટ્રેટ તરફે સાહેબ કોઈ તોમતદારની ઓળખ પરેડ થયેલ નથી.
સરકારી વકીલે જ દલીલ કીધું કે ઓળખ
હાજી,
પરેડ નથી
જી
કરી.
જી જી.
ચાલો.
હવે આમાં સાહેબ આ પૂરા કેસમાં ફરિયાદને સમર્થન મળે એવો કોઈ પુરાવો નથી. એટલે ઓનરેબલ કોર્ટ ઇઝ હમ્બલ રિક્વેસ્ટેડ ટુ ગીવ એક્વિટલ.
2 કેરેટ ટમેટા પાછા મૂકો.
જી. રિકવરી થયેલી જ નથી ને સાહેબ.
તો તમે લઈ ગયા અત્યારે કેટલી કિંમત થઈ ગઈ હોય એની?
1200 રૂપિયા કેવી છે કઈ? 1200 રૂપિયા.
અત્યારે વધી ગયો ને, અત્યારે તો 200
અત્યારે તો વધી ગયા. અત્યારે વધી ગયા.
ચાલો,
અમે તો
બીજું?
સાહેબ જેલમાં જ, અમે તો
બીજું છે?
કસ્ટડીમાં જ હતા સાહેબ. તો અત્યારે મોબાઈલ હાલી હવે.
નંબર 2-3 તરફે છે.
આ 3 વકીલ રોક્યા છે ને, એ જ બતાવે છે કે ટમેટા ચોરી કરવા વાળાના વકીલ વધારે રાખી શકે એમ.
1-1.5 વર્ષ જેલમાં રહ્યા છે. માં મુસીબતે બેલ આઉટ છે એમ.
આ કેસમાં 1.5 વર્ષ જેલમાં રહ્યા.
હા સાહેબ.
ઓહો. તો ત્યાં કેટલાય ટમેટાનો ઉપયોગ થયો હશે ને.
હા. પછી એમાં 379/3 આ કામના આરોપી વિરુદ્ધ લાગુ પડતી નથી.
લાગતું જ નથી.
નહીં લાગુ પડતી નથી.
આ એ જે લાગુ કેમ નથી લાગુ પડતી?
તમે બોલો ત્યાં સ્નેકિંગ હોય કે મોબાઈલ હોય તો
એવું ક્યાં છે? આપણે જોઈ લાવો ને, મારે જોવું હતું. મારે તો આયોને પૂછવાનું રહી ગયું કે કેમ
હા એટલે
કેમ ન લાગે એકોજી? તો ચોરી લાગે.
ચીલ ઝડપ નથી ને એમાં. ચીલ ઝડપ કે ને ચીલ
અરે
ઝડપ.
ચીલ ઝડપ તો હતી. SS માં આવ્યા, લઈને ભાગી ગયા. જમાલપુર થી આખો બ્રિજ ક્રોસ કરી ગયા.
ના ભાઈ એટલે અમારા આરોપી નંબર 2-3 હા સાહેબ એટલે હા નંબર 2-3 નો સાહેબ એમાં કોઈ રોલ નથી. પાછળથી પકડવામાં આવેલ છે અને એમના વિરુદ્ધમાં સાહેબ કોઈ પુરાવા મળી આવેલ નથી. કોઈ મુદ્દામાલ મળી આવેલ નથી અને સાહેબ ગુનામાં કોઈ ભાગ ભજવેલ નથી અને કોઈ પંચાયત સાહેબ મદદ કરતા નથી. ત્યાં નામદાર કોર્ટે આ આરોપીને છોડી મૂકવા જોઈએ. નિર્દોષ ઠરાવી.
સ્નેચિંગ તો છે પણ ભેગી ચોરી એ છે.
હા ચોરી છે. પણ સાહેબ 1/3 નહીં લાગુ પડતું.
એ ભાઈ
1/3
હા, એટલે એ તો આવ્યું છે 379 એ પછી 1 એટલે એ લખ્યું છે એ લોકોએ અને 3.
હા સાહેબ આ કામના આરોપીનો સાહેબ આ ગુનામાં કોઈ રોલ નથી. કોઈ રીતે સંડોવાયેલ નથી.
રોલ નથી. જામીન અરજીની દલીલ હોય, પુરાવો નથી એવી આમાં.
કોઈ પુરાવા નથી.
ચાલો હવે કોણ બાકી રહ્યું?
શીતલબેન ધીરજભાઈ એમને એવો મેસેજ હતો કે એને ઓલા ડિલિવરી આવી એટલે ટાંકા તોડવા લઈ ગયા હતા. બેનને ડિલિવરી આવેલી છે 20-25 દિવસ પહેલા.
એક્ઝમ્પશન આપી છે.
હા મેં કીધું તો કે હું એમાં એડવોકેટ નથી, હું રેકોર્ડ પર નથી થયો.
એવું કેતા હોય તો એવી એક અરજી મોકલી દેતા હોય તો આવું કઈથી હું શું કરી શકીશ આમાં? કો રેકોર્ડ ઉપર
ફોન
કે
હતો.
એક અરજી એક્ઝમ્પશન આપી દેજો.
હા હા.
ચાલો બીજી દલીલ છે હવે કઈ?
ના
નહીં. ચાલો
મેટ્રોમાં જવાનું સાહેબ એટલે જવાનું.
અત્યારે ક્યાં મેટ્રોમાં?
મેટ્રો
કોર્ટમાં એમ.
મેટ્રો તો આખી મોડે લગી ચાલુ હોય છે.
ઈ કાઢો.
અરે કોર્ટમાં જવું છે. મેં તો કીધું આ મેટ્રો ચાલુ કરીએ છે. કોર્ટ ટ્રેન
એ તે બાજુમાં જ છે ને. મેટ્રો રેલવે
એ
બાજુમાં
બાજુમાં જ.
મેટ્રો કોર્ટે બાજુમાં જ છે. ઈ કાઢો કોર્ટમાં જવાનું.
તારીખ પહેલી તારીખ
એક ઓબ્લેસ આઈ લ્યો.
છે ને શીતલ
નહીં.
થશે આરોપીઓ તો હાજર છે ચારે હે નથી આરોપીઓ તો એ જ છે ને લીગલ માંથી એક આપી દો ને અરજી એની હાજરી માફીની અરજી અપાઈ દેજો ને પેલા બેન. હા તમે આપી દો ને અત્યારે કે આવું છે ને આવી એમને જાણ કરી છે
હું અરજી મોહમ્મદ ચાની અરજી
4 નંબર છે ને 4 નંબર નું તમે કીધું પેલા કહેવાય.
મિસ્ટર એમ એમ અંસારી એમાં
હા એમાંથી કોકે એક અરજી આપી દેજો ને તમારા બંને માંથી એક એક્ઝામ્પશન
હું આપી દઉં છું અરજી હું આપી ના ના જુનિયર
કોઈ
છે ને
જુનિયર ને કહી દો ને
જુનિયર છે ને એ આપે લખી આપે ભાઈ આવું
હા
My request, serial number 9 છે revision application. રિક્વેસ્ટ કે એ દિવસ રાખવામાં કે અંદર કોર્ટના ટાઈમ
એ અત્યારે નક્કી થાય આજે જોવો જોઈએ અત્યારે કેટલા વાગે
માનું છું સર સર એપ્લિકન્ટ ને સર ઓપન નંબર 2 ની આઈ થિંક આર્ગ્યુમેન્ટ્સ આવી ગયા છે એમ ફોર ધી ઓપન નંબર 5 to 8 so I will argue on orally this
તારીખ
9 number
સપ્ટેમ્બર માં આપી.
નો સેટરડે ઓગસ્ટ 14 તારીખ
હા તો તમારા વકીલ સાહેબ આવશે એમાં
is a revisionist
અચ્છા હા તો એમાં તો તમારા વકીલ સાહેબ આવશે ને તમારી જરૂર નથી કઈ વાંધો નહીં ભલે ને આવી ગયા સારું કહેવાય ત્યાં મેટ્રોમાં જઈને પછી આવજો તમે ત્યાં. હા 14 તારીખ
on second sitting so this is my request for second is the revision so
એવું હું કઈ નહીં કહી શકું અત્યારે પણ હું તમારું સાંજ લગી રાહ જોઈશ
please
હા 2 નંબર એમની તારીખ આપો સપ્ટેમ્બર ની
સિરિયલ નંબર 21 છે
સિરિયલ નંબર
સિરિયલ નંબર 21 છે કેસ નંબર 188/21 છે સાહેબ 21 બેઠા છે
શનિવાર
સવારમાં એકચ્યુઅલી સાહેબ આમાં એપીપી સાહેબની લેખિત દલીલો 5 મુદતથી બાકી છે ભલે
એ ઈશુ અનિક ઈશુ એ ઈશુ
ના 15 બોલાય ને મારી સંપૂર્ણ પ્રયત્ન કરીશ તારીખ પહેલી કે બીજી વાર એ ચાલુ છે ને? આમ પહેલી કે બીજી સેકન્ડ કે પહેલો જ છે હા આપી દો 2 નંબર
હાજી
પેલામાં 188 ના ના 100 હા 188
એપીપી બીએસ પટેલ
પહેલી તારીખે છે. 2 પછી આપણે